All right, session 3 for the day is starting. We'll let you guys all migrate in as you're pushed over. I can see most of you are already here, but we'll let you get settled. So for this session, we have our first for North America side. It's not a panel because I'm going to mute myself. Is a panel 2 people? It can be a panel.
I guess
A
so.
duo.
We call that.
A duo. The e-Discovery chicks, Bree Murphy and Angie Nolette. And so they're going to take it away. Just as a heads up, if you're just now joining, if this is your first session, the chat, the QA, and the polls that we'll be running are all on the right side of your screen, or right looking at your monitor. And so they will signal polls coming up, and we will go through those. But if you have chats and QAs, yeah. While I hand it off to them and they're introducing themselves and going over the agenda in the chat, let Angie and Bree know whether you're in forensics focused, e-discovery, privacy, or cybersecurity. Just drop that in there, kind of your main vertical genre of where you are in that. And yeah, so Angie, Bree, I'm going to hand it off to you, and thank you again.
Well, thanks, Justin, and thanks, Exterro, for having us here today. Angie, I feel like we're super blessed to have because she's in Hawaii, guys. Like, how do you have such a fancy life, Angie? I'm just in Houston, where I always am.
Oh my gosh. Well, it doesn't feel so fancy right now. There's a massive storm rolling in, so let's just all cross our fingers I keep my internet.
Okay, well, I'll introduce myself first, and then Angie, I'll throw it to you. My name is Bree Murphy. I am co-founder and co-host on the e-Discovery Chicks podcast. We're excited to be here today, and thank you for including the e-Discovery Chicks to have a little bit of a different spin in the forensics world today. I also work for Exterro as a senior solutions engineer with an e-Discovery focus. I've been here for 3 years. Before I came to Exterro, I was a client. I worked in-house at a global insurance company as the e-Discovery manager. Prior to that, I've got about 15 years of working in different law firms here in town in a litigation paralegal / litigation support capacity. I am also on the board, the Houston board of ACEDS here in town. I am the membership director. I have previously served on the board of Women in E-Discovery, but now I'm just a member enjoying all of the benefits of what that organization brings. But it's my pleasure to introduce you to Angie Nolette, who is my partner in crime on the podcast.
Hi, everyone. Yes, I am Bree's partner in crime. I've been a lawyer for about a decade, and right now I am the Senior Corporate Counsel of Litigation and E-Discovery at a national publicly traded company. In previous lives, I've been a trial lawyer for the regional firm of Lane Powell, which is now Ballard Spahr, where I specialized in commercial litigation and design build disputes. Before that, I was a deputy prosecuting attorney at the King County Prosecuting Attorney's Office, where I specialized in gang-related crimes. And then in my free time, I like to restore vintage cars, write science fiction, and collaborate with Bree on the e-Discovery Chicks podcast about all things e-Discovery and legal tech.
Yay. Well, we are excited to be here today. This is our agenda, which I'm not going to read point by point, but the idea today is to provide a full perspective of investigations from a corporate point of view. And I'm seeing that we've got a lot of forensic folks in the chat anyway. So I'm not sure what your level of experience is with the corporate investigations, but the idea today is to understand the end game of a corporate investigation, what it involves, and highlight where your forensic expertise is truly relied upon and where you can really create the best value for not only your own career, but also for your client or customer that you're trying to serve, which is the internal legal department. But before we get started, you guys have fancy polling that is going on in this webinar. So we have a poll question for you. Let's see. Oh, here it is. Okay. So in handling corporate investigations, I get the most heartburn when thinking about, and here's some 4 things we thought of that might potentially give you some heartburn. So we'll give you a moment to submit your answers. And I should have put an other Angie, because I'm sure we didn't even think about all the things that people stress out about.
You know what? Full disclosure, I actually just took the poll. So.
Oh, did you?
I did, yeah.
Does your response count? I don't know.
No, probably not.
Well, we are going to talk about some common investigations, but before we get started, do you think we've given enough time to answer the poll? Let's see. I don't know, Justin, if are you able to share the results, or do we need to give more time?
I can share the results with you, as they're still kind of coming in, but
okay.
I can give you the results.
Well, we can keep going. I mean, we don't have to be up against a time clock.
No, here you go. Let me give you the results in case you want to comment on them. So when handling corporate investigations, I get the most heartburn when thinking about privacy concerns was 40%. Communication with legal teams was 14%. Lack of tools and or software was 36%, and lack of personnel was 9%.
Okay, that's very interesting. Thanks for that insight, guys.
Well, we're going to touch on all 4 of those things during the course of this presentation. So stay tuned. For the record, my response was lack of software. So I was in the majority. I don't think I skewed the results too much.
Well, so we're talking about several different kinds of investigations that you might encounter in a corporate environment. So one of those is going to be your internal investigation. What does that mean? Well, usually, if you're not familiar with this space, this is going to mean something like an HR issue. Sally and Bobby had some shenanigans going down at the water cooler. We need to investigate, or maybe some sort of discrimination issue has come awry, or I'm not even saying that right. maybe there's been a discrimination issue that's come up. We also can think about internal investigations being things like theft of property, theft of people, data loss is another way of saying that. We also can think about data incidents. Maybe something has occurred, maybe something with a third-party vendor or the like, and we need to investigate internally what's happened within our organization.
Yeah, another common investigation is going to be one that's related to litigation. And when I say litigation, that's actually a broader term than most people think of it. Most people hear the word litigation and they think a lawsuit, but it's actually broader than that. It can include subpoenas or even the proactive, should we sue someone? And in all of those instances, you've been sued, you're thinking of suing someone, or you've received some sort of legal document that requires you to take action. All of that is part of litigation, and you're going to have to investigate your data to determine what you need to produce in response to that. Then there are government requests. Those come in the form of a formal civil investigative demand, or CID, or they can be more informal. The DOJ and the FTC are 2 government agencies that are currently pretty active when issuing these requests, and they can come out of the blue to companies, and they typically involve a pretty tight turnaround. You might just get a CID out of the blue from the FTC and have 2 weeks to produce a couple gigabytes of documents. And all of those need to be found, reviewed for privilege and responsiveness, and then produced.
Yeah, and another thing to consider too in working with corporations is that there's a lot of routine processes and workflows and procedures that happen that could actually be the spawn of an internal investigation. Like, for example, you might have exiting procedures for personnel who are in high profile roles within your organization, or personnel that have access to competitive information, for example. Maybe part of that exiting workflow with IT is to do just some very precursory investigations. What did that person do last? What was their activity in the last couple of weeks? Have they sent anything outside the company, et cetera? It could just be something very rote and routine, and as a result of the findings, could launch a full-on investigation. You also might have corporations who are running security audits or some sort of activity monitoring, maybe looking for or, bulk purging or moving of data, or access to sensitive locations within the network. When those audits or those monitors trigger that behavior, it could very well lead into a full-on investigation. So it's important when you're involving yourself in these types of investigations as a forensics expert to truly understand, how did this thing get started in the first place?
And that is the perfect dovetail into our next slide, which is, how do you conduct a successful investigation? What can you do to set yourself up for a win? And we come with 3 big tips here. Number 1, understand the big picture. Number 2, scope your work. And number 3, prioritize. So as far as understanding the big picture, what you really want to do is figure out how your investigation fits into the larger objective, and then strive to further that goal. For example, if your organization is investigating, let's say like theft of trade secrets, you want to know that your investigation of the CTO's email is supposed to further that goal, so that when you're looking for something in the CTO's email, you've got a frame of reference and you can better understand what is relevant to the larger inquiry. The next thing is to scope your work and determine why it's relevant, or determine what is relevant. So why are you even involved? Why are you searching through the CTO's email? What is going to be relevant to that investigation? But then also, are there other people you should be searching? Are there other data sources you should be thinking of? And then how does your work contribute to the bigger goal of answering the one question? Did the CTO steal trade secrets from the company? You also want to consider what jurisdiction you're in. A lot of jurisdictions have kind of finicky or very specific rules about how you can collect data or how you can handle that data. And so you want to be cognizant of those particularities when you're doing your investigation, so you don't wind up in a situation where you've done all of this work but failed to comply with some local rule and all your work becomes meaningless. You also want to consider your audience. Who are you going to present your findings to at the end of your investigation? Is it going to be a lawyer? Is it going to be somebody technical? Is it going to be the judge or a jury or some other arbiter? Because you want to be able to speak on that level. And so when you're doing your investigation, if you know you're going to be talking to somebody technical at the end of it, well, you can get into the nitty gritty and they're going to be right there with you, tracking everything you're saying. But if you're talking to a judge or some other third-party arbiter or a lawyer, we ain't technical people. So you're going to have to speak a different language when you're conveying your findings. I'd also say consider the allegations. I used to work in the criminal sphere, and so we would often collaborate with detectives to find evidence. And it was always so that we could prove one specific element of the crime. Here, I'm just going to keep going with this CTO theft of trade secrets analogy. But if that's what you're trying to prove, understand the elements of that crime or of that charge so that you know what exactly your work is speaking to. We would have the best detectives I've ever worked with were ones who understood that their job was to speak to one element of the crime. And then they would just go all out speaking to that one element. And it was so helpful because you're kind of the project manager as the lawyer in that situation. But it was helpful to have somebody who was like right there with you, rowing in the same direction, all operating towards the larger end goal.
Yeah, and going further into scoping your work, all of what Angie said, kind of leads into that. We need to figure out what's in scope here. And by the way, I would say maybe this is a pro tip, or maybe it's a no duh for some people. I don't know. But I know when I was working in-house, I kept a big, huge list of, these are all the things that I ever could possibly consider in a forensic investigation. Now, understanding what your matter is will tell you whether or not you're going to go boil the ocean or whether you're going to, take a very controlled perspective on your investigation. But having all of the potential possibilities of what you might do kind of allows you to make sure that you're not forgetting anything. You're not forgetting to ask any questions, because there's so many perspectives that you need to consider. So when we talk about scope, and by the way, I see somebody asking if the slides are going to be available. Yes, we're happy to make the slides available. So hopefully they're helpful for you. But when we talk about scope, we're talking about who are the people involved. Are these employees of the company? Are these also people outside of the company? Because who they are might determine where that data is, who owns that data, who's in control of that data, and the way in which we go about collecting it could be very different. If we're talking about a mobile device of my employee, I have a lot of control over that if I have properly put in place something like a BYOD policy, for example, that employee has signed off on. That's one circumstance. And then you could have my employee's ex-girlfriend's phone, who's not an employee of the company. That would be a whole other, can of worms, right? So the way in which you go about collecting the data or the evidence for the person, kind of like, hi, I'm not even making sense, Angie. The way in which you go about collecting data for different individuals and who they are, what their roles are, could really kind of change things up for you. Also, when we're talking about scope, we're considering data sources. So maybe we're looking at all internal data sources, like somebody stole something, we see it on a network share, we see there's activity on the company PC, but maybe this is something that involves external resources. Maybe this involves a dash cam of a car or a video at a location that's not on company property. There are so many different pieces of evidence that can come into an internal investigation. It's important to really understand the scope. And also, I would say this is a way that forensic examiners can bring huge value to your attorneys, which is to kind of go down the road of, oh, you had a car accident. Okay, was there a dash cam? Yes. What else might be in that car? Who else was in that car? What other devices might be available? What are the potential possibilities of any and all data that might be available at that crime scene? That's something a forensic investigator or examiner could really help out a legal team who's not thinking all the way outside the box of all the different possibilities. Who would have thought your Aura ring that you were wearing was actually going to have some data on it that we need to consider for this investigation?
I was going to say, the weirder the data source, the less the lawyers are likely to know about it. Ergo, the bigger the impact you can have.
Exactly. So Angie already hit on, the allegations that are involved, and that is super important. And I mean, maybe that's a no-brainer too. But when we talk about prioritizing, they actually do play a big role in that. I mean, what are we talking about? What's our loss? What's the risk to the company? Some questions internally a legal department's going to ask themselves is do we need to take out a hit on our insurance policy? Is this hit so big that we're going to have to file an insurance claim? Is there going to be any kind of media presence? Is this in the news? Are we going to have the press calling us? Do we need to get our internal teams involved so that we can cover our butts? What's the budget on this? I mean, what does this really mean to the company? Is it worth going after everybody's Oura ring in the car? Or is this really not a big deal, a big loss to the company? And what's the ultimate
Stay away from my Oura ring. My readiness score is
every time I say Oura ring, I think Angie's like, oh no. But what's the risk to the company at the end of the day? And those are the questions that your attorneys are really going to be able to answer, but you should be asking and clear on at the very beginning of any type of investigation.
Can I just add one thing to that really quickly, which
Sure.
is I love when people push back on me because I'm not the expert in these fields. So I love when I ask, my experts a question and they're like, that is absolutely not the right question to ask, or there's really a better way of doing this. It is so helpful because you all are the experts. And so getting that expertise out in the open is just invaluable.
Yeah. And so now we're kind of getting into the collaboration side of things. The investigation has launched. Now you're collaborating with your team. It is okay for you guys to say things like, hey, when working with my clients, it works really well when we can have a meeting, to get all on the same page with all of the stakeholders, because everybody is going to have their own individual role in this investigation. And it's important that you all understand and agree on what the scope of your individual roles are. And you also brainstorm to see maybe there's other stakeholders that need to be a part of this that we haven't even considered. A real popular, thought process to not consider if you're a legal department in a corporation is like data security or individual like IT application owners or people within the organization that are subject matter experts on that technology. Sometimes legal teams aren't thinking that they need to have a seat at that table at the beginning of an investigation. But as a forensic examiner, if you're in charge of the data and you're trying to piece together a story, you're sure as heck need to know who those people are, what's available to you, or what's not. So I just encourage you, if your legal teams aren't doing it already, encourage them to involve all the stakeholders. And these could be people like I already mentioned some examples in IT, but it could also be people in engineering who have engineered, coding on websites or homegrown applications. It could be even external experts. You could be working with a private eye, for example, or it could be some sort of subject matter. Like one of the most intricate litigation cases that I went to trial on had to do with a freaking railroad tie, Angie. And it was so complicated of how the thing was engineered and how it worked and an accident that happened and blah, blah, blah. We had to get all these people in from all over. I never would have imagined in a million years that I'd be talking to or have to explain in court, right? So there could be subject matter experts outside of the company that you're dealing with as well. And then I would say also be open to understanding and explaining to your legal teams what the capabilities are of different data sources and also what the limitations are. Attorneys are, and no offense, Angie.
None taken. We're not a nice.
Super bad at thinking that something has an easy button and like, we'll just get the stuff on the stuff and then tell the story about the thing. And they don't understand what it actually takes or if it's even possible. Of course, Angie does. She's different. She's special. But
You're
a lot of times,
unicorn.
You are. A lot of times it takes you proactively bringing that up and having some visibility to set expectations.
Yeah. There's this sort of mantra in the legal profession that law firms thrive on people who are ultra insecure and ultra high achievers. So humility is like not in the playbook for those people. So you might have to educate them and push hard. It's worth it because what you have to say and your expertise, it really matters. It drives so many efficiencies that might be just squarely within your legal team's blind spot. And in that vein, it's important to speak a common language because every discipline, every profession, every specialty all has its own vernacular. So you got to make sure you're understanding each other and not just throwing jargon out and talking past each other. I had a situation, I don't know, maybe a year ago at this point, where I was talking to an engineer about Slack data for like 30 minutes. And I thought that this person was off their rocker and they thought that I was off mine because I was talking about Slack, the messaging application. The engineer was talking about the interstitial space on hard drives. And after a couple exchanges where we kind of looked at each other like, what? I finally was like, wait a second. I'm talking about the messaging platform. What are you talking about? And we got on the same page, but it was this really important lesson of, hey, when you say a term, when you're talking in jargon, make sure that the other person is right there with you. Otherwise, you might end up talking about the wrong thing for 30 minutes. So yeah, I would say make sure a great example is legal hold. Some people mean the actual just like paper notice or email that goes out. Other people mean something entirely different. They mean the act of locking that data down. And this is one of Bree's favorite soapboxes. And I know we're going to cover it in a couple minutes. So I won't go into any further detail there, but just make sure you're on the same page.
Yeah. And I see Tommy in the chats talking about some issues that you've run into dealing with corporate folks. One is not having full disclosure, and two is unrealistic expectations of how long it will take and what information is available to you. I totally agree. This is a completely normal place to be in terms of you're dealing with a legal department and a forensic examiner, even a legal department and IT individuals as well. That conundrum still exists. And two things that I will say about that is one, the better questions you can ask a legal team yourself, the more visibility you will get from those attorneys. A lot of times and I'd say attorneys, but I also mean attorneys, paralegals, legal assistants, and even e-discovery professionals that are working underneath that corporate legal umbrella. Many times they don't understand themselves what you need to be successful at your job. So the better questions that you can ask, the better information and the bigger picture you're going to see. And I think that is something that actually comes in time with practice too. I mean, I have learned, here's 50 questions that I need to make sure that I know about this subject before I can really intelligently proceed with my recommendation of what we need to do next, right? And then the other thing is that expectation of time. How long is this going to take? What can I get? Perfect information for you guys to be sharing, not only at the very beginning of an investigation, but all throughout, keeping that communication flow going. All right, so policies. We're not going to talk about this a whole lot, but there's a few good policies that you should know about in your investigation that may exist or not exist at a corporation that could very much impact how you run your own investigation.
Yeah, so the first one of those is going to be a BYOD, or bring your own device policy. That is a policy that dictates the rights and responsibilities of employees who use their personal devices for work purposes. And it lays out not only the individual's rights and responsibilities, but also the company's. So typically these will say under what circumstances a company can access data on that personal device. And sometimes they'll go farther than that and say, how the company intends to do that. But they're really important because employees who use their personal devices for work are going to have work-related data on their phones. And that data might be relevant or even critical to these internal investigations. So you want to have a plan in place for how you're going to get it. Second policy that we strongly suggest having in place is a retention policy. A retention policy dictates how long organizations keep data. It's important to enforce these policies because a toothless retention policy is pretty much worthless. That's because if an organization is asked for data, they need to be able to say, per our retention policy, we deleted it after X number of years. And if that retention policy is followed and enforced, deletion becomes a matter of course and not an object of suspicion. Imagine a company like on the converse that says, per our retention policy, we should have deleted this data, but we didn't. It's like, well, why'd you keep it? Or, well, we've got this retention policy, we never enforce it, but we did in this one situation. That suddenly starts to look pretty fishy. Whereas if you just followed the retention policy, it would look like a matter, like the usual course of business.
Yeah. And I would say too, why do you care if there's a retention policy? Number one, it kind of governs what is available to you as the examiner to refer back to. If you're looking at a PC doing an examination of files or folders, or you see link, files or shell bags or whatever in the unallocated space, and you have to go back to the original application to find that, it might not be there because there's a retention policy that's run its course and has purged the original data. So that's part of setting those realistic expectations. Yeah, I found this, fragment of information, but I can't make heads or tails of it because you don't have that information anymore in your system. The other thing to also consider with those retention policies is, gosh, Angie, I just lost my train of thought.
Hey, it's early for me. You have no excuse.
I know. I was like on a roll. But we'll move on to change management policies. How about that? So change management policies. A lot of corporations have change management policies in place, which do things like, hey, every quarter or every year, we need for the application owner to attest to what application this is, if it's still being used, if the retention policy is important to follow because it affects the admissibility of your investigation in court. That's what I was going to say. Sorry. So change management.
More coffee.
I know. I'm sorry, guys. I'm trying to keep it together. But for change management, you want to make sure that you understand the application in-house. What is it in a foreign jurisdiction? Has it been decommissioned at some point and this is a refreshed application? What has happened with the life cycle of this application? That matters to you because if you have to tell a story and you have to refer back to things like activity logs in an application, for example, and you're like, am I going crazy? They're not there. What the heck happened? Well, you realize, oh, well, they decommissioned the old version of this and they updated it and they purged all the audit logs. Well, dang, we can't get that. So having that understanding of change management and retention is so important. And I think it's something people forget to ask about and forget to go down that rabbit trail internally with the corporation to really understand what's available to be part of your investigation. Audit, this probably goes without saying. We need to make sure that all the policies that we have in place actually freaking work and are being followed, because when they're not, we have problems with the court because they think that they're going to throw out all of our evidence or not allow us to get away with the fact that we don't have the evidence because we're not following our own policies. So have checks and balances, understand whose role it is to do a regular checks and balances of all of your policies, and training. What good is a policy if nobody even knows it exists? And by the way, I'm seeing an acceptable use policy being called out in the chat, and that is a great call out. So thank you for that contribution. For all of our policies, people need to know what they are. What the heck does this mean? What is my own obligation? When does this need to be something that I consider, and why? Training can be done in a variety of different formats. You could have it as part of onboarding. You could have it as part of, a quarterly training deck that people have to, go through, all the training that we all love to do, right? You could have webinars. As a forensic examiner, if you are a service provider, you're a forensic examiner in your day job, a wonderful service you could do for your clients would be, hey guys, let's do a lunch and learn. I'll bring the sandwiches. Let's go through what it looks like, what shell bags are, or what this workflow is forensically. That is a super service to offer to your clients so that they can better understand what you're doing and what your logic is and how you're getting to your findings. And I think that, as a customer, when somebody reaches out to me like that, I value your intel. I value the quality of your investigation, and I value that relationship even more. So just an idea there. All right, Angie, you talked about legal holds a second ago. So, I feel like you kind of, gave away my little, what I like to get on my, what do you call it? My pedestal.
Your soapbox.
Yeah, my soapbox. That's what I'm trying to do. So legal hold versus preservation. This is one of those funny things that, much like Angie's Slack example, I have on a daily basis because I work for a company that sells legal hold software. And when we get on a phone call with somebody in legal or somebody in IT or somebody in forensics or whatever, we must establish what kind of friggin' legal hold we are talking about. Are we talking about the legal hold notification that legal is sending out to individuals and or data sources or individuals that are in charge of data sources that's telling them, hey, you're on a legal hold and it's your personal responsibility to preserve this data? That's a notification. Or are we talking about the legal hold that is actually in place preservation, meaning we are saving data, we're locking it down in the back end so that nobody can inadvertently purge data on accident, right? So that's one thing to really, as you're talking with legal and you're talking with IT, make sure that everybody's on the same page about whether you're talking about the legal hold notification or the actual in-place preservation legal hold that's being implemented through the technical layer.
Yeah, so about the when and the why. When do you need to put a legal hold in place, and why do you need to do it? So you need to put a legal hold in place when litigation is reasonably anticipated. That is the standard in law, and it's a squishy one. It can mean anything from you get notice of a lawsuit to you're issued a subpoena to your chief legal officer is at a cocktail party and overhears some other company's chief legal officer talking about how they really want to sue your company. So it's squishy and it's very fact dependent. But if you've got an inkling, if you think, hey, they're probably going to sue us or issue us a subpoena, that triggers the need for a legal hold. And when I say that, I mean both of the things that Bree just said. I mean that notice, and then I also mean locking something down via in-place preservation. And the reason that you have to do that is because that trigger, when you reasonably anticipate litigation, that is when your duty to preserve data arises. And if you don't do it, if you don't meet that duty and data is deleted or spoliated, you can be in big, big trouble. Courts can fine you, or they can sanction you, which means they can fine you, they can issue an adverse inference instruction to the jury. And I'm seeing a question in the chat that is, who can issue a legal hold and does it require court interaction? So anybody with the appropriate amount of authority can issue a legal hold. That's a super squishy standard too. It can, in small companies that maybe don't have a legal department, that could be somebody just in the C-suite. Bigger companies or organizations that have a legal team, that's typically somebody on the legal team who's issuing the hold. And it does not require any kind of court interaction. There are perhaps, well, unless something goes awry. So if you think that a company, if you're litigating against a company and you think that perhaps they didn't do that legal hold process correctly and that data was spoliated, then you can go to the court and seek relief. But just instituting a legal hold itself doesn't require any kind of court interaction. It's all internal. And the reason you need to do both things, you need to issue a notice and then you need to lock that data down, is because sometimes employees will have data that you maybe don't know about as the legal department. And so they need that notice to ensure that they are on notice to preserve that data. For example, they might have stuff on their personal devices, on their phones or whatnot that you don't know about as the company legal department because it's not something that is within the company's kind of Rolodex of data sources, but the employee might know. And by issuing that notice to them, you're alerting them that they have additional responsibilities to preserve that data.
I would say, Angie, too, as a forensic examiner, if your attorney or your legal team hasn't provided you with a copy of the legal hold notice that was sent out, ask for it. Because in the legal hold notification, it's going to list, generally speaking, what the matter is all about, who is involved, who are the custodians, which is the word we use for employees internally, who are the people, what data sources do they feel like are needing to be preserved. And a service you could offer is check that legal hold out. Like, are you looking at this notification and you're like, bruh, they forgot like the friggin' mobile phones. Like, why would they not put that on legal hold? Good call out. Talk to your legal team. Maybe it's an oversight on their part and that you could really offer great value by sharing that information.
Totally. I mean, if you're looking at a legal hold and you're like, hey, this is a burglary, they've got a smart fridge, that fridge might have data, let's preserve that data. Or a wearable, a pacemaker maybe. If there's a case where someone committed arson and they were incriminated by their pacemaker, actually. They said, I was asleep the whole time. I had no idea. I woke up and the fire was going. And the insurance company got a hold of the pacemaker data and was like, nah, you weren't. You were up and moving around. So back to my thing of the weirder the data source, the bigger your impact.
Mm-hmm. So I feel like we've kind of talked a lot about data retention. Angie, was there anything additional that you think we haven't covered that you want to throw in there?
I'll just throw in two super quick things. A couple of common challenges that we're seeing these days are data sprawl. I mean, think about how many apps you interact with on a day-to-day basis. Probably like 50. Or maybe I'm just too attached to my phone. I don't know. And so you think about how many data sources you interact with on a daily basis. All of those need to be preserved and potentially reviewed in a way that they just weren't, 10 or 15 years ago. And then you've got legacy systems. So those are the systems that, you've got the data, but it's really difficult to access, or there really isn't a system for processing it now. I think last time Brianna gave this presentation, she mentioned like a printer from the 80s or something like that. And that data technically exists, but I mean, how do you really get to it? And who really knows how to access it? And I see in the chat, we've got a question about legal holds, time and dates to determine if any modifications have been made after the submission date related to the legal hold. I think what you're asking, and correct me in the chat if I'm wrong, is what happens if you issue a legal hold and after that data is modified or changed. That should not happen. Typically, if you've got some sort of in-place preservation system in place, it will prevent modification of data that is subject to that legal hold. If not, that's what that notice is for. It's to alert people that you shouldn't be tampering with, you shouldn't be messing with that data after that hold is issued.
All right, so we're going to move on to some tips on how you can investigate collaboratively. Anything you want to say to get us kicked off before I go into tip number 1, Angie?
No, I don't think so. We're going to give you 5 of them, so buckle up.
Yeah, so tip number 1, talking about chain of custody. And guess what? It's time for another polling question. Justin, I hope you haven't fallen asleep yet.
Nope, I have not. Great presentation. It should be coming up right now.
All right. So
I took this one too.
Oh gosh, Angie, you're such an overachiever. How important do you think chain of custody is to a corporate legal team? So let us know what your thoughts are on that, because I have my own thoughts too. I don't know if I should answer though. I might incriminate myself.
Really quick before we read the poll response, since we're getting some questions about this in the chat, the question is there a need to refresh the legal hold notices to custodians if some time has gone by? Absolutely. So typically, depending on the size and the complexity of the lawsuit, you're going to do 2 different things. One, you're going to reissue that legal hold to people on a regular cadence. Could be 6 months, could be a year, just depends on the case. But you want to remind people of their obligation to preserve data. Number 2, the lawsuits change as they progress. They get more complicated. Claims are added and dropped, and it can kind of morph over time as you go through the discovery process. And so you might need to actually rescope your legal hold at certain intervals throughout the lawsuit. You might need to add people or release people. You might need to add data sources or release them. And so that should be part of your workflow when you're litigating.
Yeah, and the part of the process that your legal team is going through in litigation, where they're considering all of your forensic examinations and all of the other evidence in the case, that's called discovery. So as legal teams are going through this discovery process, there's always new facts. Well, not always, but a lot of times there's new facts that are being revealed. In fact, you guys could be revealing new information as you are conducting an examination. Maybe the attorneys originally thought there was an initial time frame that the crime took place during, and you're finding no, it's actually not within that time or date range at all. It's actually beyond that. Well, that could be a reason why you go back and update your legal hold notice, because now we have to consider another time frame that wasn't even mentioned in the first time around. So this is another example of why that constant communication back and forth with forensic examiner and legal team is really important, because if you're finding something that broadens the scope, it could even be more people that need to be involved, or different kinds of devices or something like that, then you need to update that legal hold notice every time that happens. All right, Justin, do we have a response for our poll?
We do. We have several, actually.
Okay.
So how important do you think chain of custody is to a corporate legal team? Extremely, meaning generally the corporate teams are on top of the process and initiate it, was 75% of our respondents said that they are at that level. 25% said depends. Most of the time there are holes in the workflows. And no one said that their team was totally clueless. So that's a good sign.
Y'all are so nice. I am glad that nobody said that. If I was voting, I would vote B, to be honest with you, because think about it. A chain of custody was originally put together by somebody with a legal mindset, right? There are people laughing at me. Don't tell my ex-employers I said this, please. But no, these are legal people that wrote a chain of custody, right? And they're not maybe thinking about what actually happens when we have to take someone's hard drive and keep up with it and manage it and document it. They might think it's really cool just to sign your name on a letter that says, I got Angie's laptop on whatever date and time, and didn't document whatever identification is on the hard drive, didn't document the type of hard drive, didn't document the encryption or whatever method of encryption was on this hard drive, didn't bag and tag it, which is my way of saying that Don't use Post-it notes on hard drives and stick them in a drawer and think that you are managing your evidence. This does not work over time.
It is not 2005. That will not cut it anymore.
Please do not do that. So I have found that the influence from forensic investigators really helped me personally to think about all the things that we need to make sure that we're documenting, because it could be the last time that you see this hard drive in the state that it's in and you actually know whose it is. Because if you are fishing in a box of hard drives with Post-it notes and they've all come unglued, you're going to have a problem on your hands. Not that I've actually lived through that at all. So I would say from the chain of custody, what we're talking about for anybody that's not familiar is we need to know from the very beginning of the device collection or the collection of data, could even be a chain of custody for cloud data sources. We need to know from the time of collection where it was, what state it was in, and we need to document that. And then we need to track that as we move throughout that whole discovery process, which is also that whole investigative process and into the courtroom. And the reason why it matters, and maybe I'm stealing your thunder, Angie, I don't know, I hope not. But the reason, because she likes to talk about the lawyer-y things, but the reason why it matters is we want it to be admissible in court. We want to be able to prove up to, Your Honor, I know that this is Angie's hard drive because I have complete documentation. It's been in this bag with this tag in the place it's supposed to be. We have managed it properly throughout the years. We've tracked its existence. We know where it is. We know that this is the hard drive in question. You want to be able to say that. And one reason why it's super important for you guys is a lot of times the forensic examiners are the ones that are actually on the stand taking the heat if the Post-it note fell off in the drawer. Like, how did you know this is Angie's hard drive? So you don't want to get caught in that situation. And I would say, as you're thinking about chain of custody and workflows for yourself, of course, think about all the information that you need for that one piece of evidence or data. Even if you're doing cloud collection from, say, like you're collecting email or you're collecting from SharePoint or something like that, there's still a chain of custody that you need to consider here. If you have great software like e-discovery software, that chain of custody is built in through the auditing process. So that's there for you. So make sure as you're utilizing that evidence that you've covered yourself so that you can prove it is what you say it is. Be completely open and have transparency with your legal team. And if you're working with a company that you are at that meeting where the investigations come in and you have all the stakeholders at the table, you need to be transparent too to their IT teams, to their HR teams, to the manager of the employee in question, because whoever might potentially touch a device, a phone, a PC, whatever, needs to understand and respect chain of custody. Please do not let HR throw stuff in their backpack, put it on somebody's desk, go give it to their buddy, go give it to IT, and then all of a sudden it trickles its way down to legal and you don't know how many people have touched it. And then you give it to your examiner that's like wanting to pull their hair out. Like, you guys, about 5 different people open this phone. Like, what do you want me to do with it now? And how do I prove where it came from? Super duper important. So I think I can stop beating that horse unless there's something else you want to add.
No, I love beating that horse. It's a great one to beat. Okay, sorry, really quick. I want to address a question in the chat. So I said there are 3 questions I always ask when I'm deciding whether to get data. And it's 1, do we have it? 2, can we access it? And 3, what's the lift of doing that in terms of time and cost? So cost meaning the upfront cost, time away from revenue generating work. Also, just the time and effort to process it. There are certain pieces of evidence that, based on where they live in the database you have to query, might take weeks to do it and take somebody away from revenue generating work for that amount of time. And all of that is going to factor into this question of, is it worth it? It's all a cost benefit assessment, and everybody has something to contribute to that assessment, right? Like, the lawyer can determine how important it is legally for their case. The people who are on the forensic side can determine, yeah, okay, it might be important, but like, this is what it's going to take to get there. So is it really worth it to you? So just wanted to address that really quick in the chat. Our second tip for being impactful is to document everything. like everything. This doesn't need to be fancy. It can be a notebook, can be a Google Doc, can be, your notes app on your phone. It doesn't matter. But it just has to be a place where you consistently document everything. And you might want to consider making it available to your team. Consider making it a collaborative space for everybody. And yeah, it doesn't need to be like, you don't need to have some sort of color-coded tabbed thing in OneNote or whatever, but you should include key information, like who's involved, what are you doing, why are you doing it, when did you do it, where did you do it, how did you do it? And that's so that you kind of have a comprehensive picture of everything you've done in your investigation. I've worked on really big cases where our collaboration space was just a Google Doc, and everybody just would type notes in there. And it was great. If I had a question about, hey, did we do this one thing? I could just Control F that Google Doc and go find it. But if we hadn't documented it in that space, that information wouldn't have been available to me, and I would have wasted a ton of time tracking down whether or not we'd actually done it. Our next tip is to have a project management system. And again, this doesn't need to be heavy. It doesn't need to be super formal. It can be pretty light and loose. But a couple of key things to consider. Number one, you want to over communicate, like that Google Doc example I just said. You want to make sure that everybody is constantly kind of in touch with each other, or at least in touch with each other on a regular cadence. Maybe you have a weekly meeting or a daily stand-up or something like that to communicate what's going on. And in those meetings, when you're communicating with people, you want to share your red flags as well as your breakthroughs. There are no bad ideas in a brainstorm either, so bring them all to the table during these meetings. But the goal is to make sure that everybody is contributing and everybody's rowing in the same direction. You also might want to open source, chuck your pride out the window, just ask the dumb questions. They aren't dumb. I often ask people from different disciplines, data analysts or engineers or IT people. I'm like, can you just explain that to me as if I'm a kindergartner? Because I want to make sure I'm being a good partner to them. I don't want to dictate the terms of an investigation if I don't understand the impact of what I'm doing. So I always ask people to explain things. And then, be like Santa Claus, make a list of the things that need to get done, the things you need to check on, the things that you need to follow up with people on, and check it twice. Make sure you've really included everything that needs to be addressed. All right, tip number 4, have a workflow. Mental load is real. And so whatever you can do to lessen it, do it. Some things to consider. What kind of work is rote? What kind of work is often repeated? Is there something that's error prone or really laborious? Can you offload that to technology? Because that will make your work more efficient and it will probably standardize it better. Then consider why you're doing this. Is there something that you can templatize? Every time an employee is terminated, you do things 1 through 5 to investigate, their systems and their devices. Great. Make a checklist out of it. Don't reinvent the wheel every time. So some examples of workflows are, you can have a super simple checklist, or you can have something really complicated like Miro or Trello or Monday.com or Asana. Whatever works for you, just put it in a format that will lessen your mental load, because every time you reinvent the wheel, you create opportunity for error. It also makes your work more defensible. You can say, hey, we didn't find this piece of information, so it probably doesn't exist, because every time we term an employee, we do things 1 through 5. We check these sources. So if we didn't have that as part of their term file, their offboarding file, then it probably didn't exist, because we do this every time.
Yeah, Andy, you get a question asking about if there's concerns that you might have as you're collaborating between a forensic examiner and legal team, that this information is discoverable in some way.
Yeah, so that's a really good question. And you should talk to whoever the lawyer is on your team about that. It's going to vary case by case, depending on your jurisdiction and the subject matter, et cetera. But there are 2 types of privilege that could apply here. So actually, let me focus on one type of privilege because we're running out of time and I think this one's more applicable. And that is work product privilege. So if you're involved in litigation, things that you do at a lawyer's direction are covered by work product privilege. So if you have that, say you have that weekly meeting with the lawyer and the lawyer's like, hey, we need to do things 1 through 5. We need to check data source A, data source B, data source C, and then we need to talk to witness D. All of that stuff could conceivably be covered by work product privilege. And if you're collaborating in a document with a lawyer, the likelihood that that privilege applies is greatly strengthened because they're involved in that process.
So I'm going to just say to you guys, I know that there's a bunch of questions that are kind of being said in the chat. So if you have something that you're asking and we don't get to it, we'll get to it later. And also feel free to reach out to us. Our website's www.ediscoverychicks.com. We're also on LinkedIn. So just throwing that out if you have questions or want to contact us after the fact. So forensic value. I'm going to sum up the slide and not go into great detail because you guys already know a lot of what the forensic value is, right? But something that I think it's important to communicate to all of you is that you have an expertise and you're being called to have your role for a very good reason. And the more that you can show what your value is in communicating to that legal team and the way that's impactful and meaningful to them, helping the legal team to get to their own bottom line, keeping the visibility there, keeping them in the loop, thinking outside the box, the more you can provide that value, the greater respect and the greater involvement you will receive in turn from your legal team. Please do not back down. Do not be afraid of legal counsel. I know attorneys can be scary, especially when they're the client hiring you or paying you for your services. Do not back down because this is important. And attorneys out of anybody understand what authentic and admissible and valid evidence is, and also understand that you need to make judgment calls and analyze the scope of what we're actually trying to do here multiple different times throughout the course of litigation. So don't back down, stick to your guns is my words of 2 cents of wisdom, because you guys really do bring a lot to the table and you have so much more visibility into what's really happening sometimes in an investigation than your legal team does. So there's a lot riding on your shoulders.
And we're just scared of you.
I know, yes. And we're scared. And something, by the way, that's like very helpful in making everybody less scared of each other is like seriously talking to people like they're in 5th grade. Like, this is a shell bag. This is what it means. This is why it's important. This is a linked file. This is what it means. This is why it's important. And when I put it together, 1 + 1 = 2. If you talk to somebody like they're in 5th grade, they're going to get it. And they're not going to think that you're being condescending. And I'm not being condescending in the way that I'm saying that. I'm being legit. Like, sometimes somebody has to talk to me like I'm in 5th grade because I'm like, whoa, that's information overload. My brain doesn't think that way. Like, you got to boil it way down. All right. Justin is coming on and telling us that it's time, I guess. So we haven't quite gotten to the end of some of the things that we were going to talk about, but we would love to have further conversation with you guys if you want to reach out.
Are you okay if while you guys say basically goodbye here in the next 2 minutes, I pop up your last poll?
Yeah. So the last poll was actually going to be presented as we talked about this slide, which was some of the different pain points and challenges that we have in today's world when it comes to forensic investigations and really just e-discovery in general.
Cool. So yeah, be sure to answer that. So the data source that presents the biggest issue for me while conducting an internal investigation. So be sure to answer that. So this was an amazing presentation. I have a page of notes. I did keep notes. I was awake the whole time, Bree.
I'm so proud of you.
And I do have a note here for pacemaker forensics, a new and emerging discipline there. But
as we're getting older, it's important for us to remember this, Justin.
Yeah.
You also Google
the port right in your chest. So Bree, Angie, you got 1 minute to say your goodbyes, and then I will hard cut it to move everybody to the next presentation. So thank you.
You want to go first, Angie?
I just wanted to say, thank you so much to everybody who attended today. This was such a pleasure. Bree and I love doing these things. And if you're curious about Internet of Things and how that can affect investigations, we actually have a podcast episode about the Internet of Things where we talk about the pacemaker, Fitbit murders, and all other fun stuff. So please come check us out. Thank you.
Yep. And thank you guys for all the hard work that you do on the forensic side. It's really important. There's a lot of people's lives that get touched in very meaningful ways and practical ways by your work. And please value yourselves as much as we know that you're valued, because your work is crucial to any investigation or discovery process that a legal team has going on. Thank you for listening to us today and for all the great questions. Hope we get to hear from you.
Thank you. All right, everyone, we'll be ending this one and moving you on to the next one. This was a great presentation. Angie and Bree, thank you.
Thanks, Justin.
Thank you.